Good afternoon. My name is Steve Curley, and I'm fortunate this year to be the chair of the Solo Small Firm and General Practice Division of the American Bar Association. Today, we're going to enjoy our second program in our Activate Diversity series this year, The Long and Tragic History of Racism, Vigilantism, and Mob Violence in America. Those of you who began this journey last year under the leadership of then Chair Elfrida Coward have already experienced some wonderful program, inspiring program. But today is a little different. Today, we're actually confronting and challenging some of the most difficult topics we've yet to grapple with in this series. And we chose to do this not only to continue the work that was begun last year, but to build on it and to take those courageous steps to make changes. This is going to be a program that will disturb you, but you've already expressed your courage in joining us today. So I applaud you for that, and I encourage you to listen carefully as we take this journey together. When you go on a journey, especially a difficult one, it's great to have partners to go along with you. We have absolutely the best partner we can imagine for this particular program. It's the National Bar Association. And to help forward the program along, we have Juan on behalf of the National Bar Association to welcome you and to introduce our presenters later. Thank you. Juan.
Thank you, Steve, and good to see you. My name is Juan Thomas. I have the honor of serving as the 75th president of the National Bar Association from 2017 to 2018. I, along with the 79 other current and past presidents, we are honored to be with you this afternoon. The National Bar Association was founded in 1925, unfortunately at a time when the American Bar Association denied membership to African-American lawyers. 12 lawyers throughout the country, primarily from Chicago and Iowa, decided to band together to found the National Bar Association in response to this denial. Thankfully, because of the blood, sweat, and tears of Black, brown, and white lawyers over the centuries, that access was opened and that injustice was corrected. In fact, we are so proud that 5 African Americans have been elected to serve as president of the American Bar Association. 3 of those 5 are past presidents of the National Bar Association. The first being Dennis Archer, Paulette Brown, and now our current president, Reggie Turner. We are so grateful for the African American lawyers who have taken leadership positions in both the National Bar and the American Bar Association. In this division, your immediate past chair, Elfrida Coward, federal court judge, J. Michelle Childs, and Jamie Boston, who not only is active with this division, but is the chair of the military law section of the National Bar Association, make us proud. And it's on those shoulders, on those ancestors, they and I stand. This program today is a continuation of the collaboration between the American Bar Association and the National Bar Association. Today, I wear both pins proudly, my NBA pin and my ABA pin, because I am proud to be a member of both organizations. Both organizations are important and critically important to the future of the legal profession and our democracy. Both are deeply needed to protect our democracy and tell the true story of our country and how the law has impacted our democracy. And so I am glad to be with all of you this afternoon. Look forward to this important conversation, and thank you all for being here. And let's continue to do, in the words of John Lewis, let's get in some good trouble. Thank you.
Thank you, Juan. Good evening. I'm Chisa Putman, Chair of the Diversity Board, and I would like to welcome back some and greet others for the first time joining us for our Activate Diversity series. Tonight's program, Activate Diversity, the long and tragic history of racism, vigilantism, and mob violence in America, was the brainchild of one of our board members, Cedric Ashley. When we initially started discussing topics for the series, January 6th was the hot topic of discussion. When I reached back out to Cedric to see if he still wanted to pursue the topic, he stated that January 6th really wasn't enough. He went on to explain that as he started to flesh out the topic more issues became evident. Look at the Ahmaud Arbery case, the Kenosha, Wisconsin killing with Kyle Rittenhouse. So Cedric went on to explain that as he started to flesh out the topic more issues became more evident. Looking at the Ahmaud Arbery case, the Kenosha, Wisconsin killing with Kyle Rittenhouse, and the case that really started to open our eyes, the young man with the pack of Skittles, Trayvon Martin. What do all these cases have in common? It's not the state and it's not the alleged crime. What these matters have in common is the person doing the enforcement is not an officer. It's an everyday person who decided to take the law into their own hands. Recalling one of the most unspeakable demonstrations of mob violence in my lifetime, think back to January 6, 2021. In each of these situations, people who believed they were above the law chose to take the law into their own hands, resulting in innocent people getting hurt and sometimes even killed. That's not the way our legal system functions. Our system works with a method of checks and balances. We have law enforcement, we have a court system, and we have us, lawyers, who ensure everyone is provided with due process. Our system functions well, not perfectly, but well when permitted to do so. But when people unrightfully decide to take matters into their own hands, they destroy our system. They are functioning off the old system that allowed the lynching of Emmett Till in Mississippi in 1955. The system that defended Raymond gun being burned alive in Maryville, Missouri in 1931. And the system that justified the lynching of General Lee in Reedsville, South Carolina in 1904. That was the old system. But was it really? Because when you truly reflect on what has been taking place over the last 10 to 15 years, is there really a difference? The purpose of this program is to enlighten you of the eerie similarities and hopefully encourage you to use your voice and your knowledge to change laws that allow these individuals to continue to tarnish the system that we work so diligently to protect. In addition to gaining knowledge from the program, we ask that you allow us to gain some knowledge from you. So each of our programs have a call to action, and we're requesting that you pledge to activate diversity. It could be through providing pro bono work or organizing a youth program, whatever you choose to do. We're asking you that you go to the chat box and we have a survey there. And we want you to let us know what you will do to activate diversity. 1 year from the conclusion of the series, we will follow up with the pledgees and recognize those who achieve their goal. Additionally, we have partnered with Maupin Elementary School, which is one of the lowest performing schools in the country. And we're asking that you provide supplies to Maupin Elementary through their Amazon wish list. They have about 285 items that can still be provided to them, and that's also located in the chat box. One last item, we would like to thank all of those who have supported this program, all of our sponsors, and all of the participants this evening. So sit back and enjoy the program. Thank you.
Okay, there's no way I'm going to hold folks up. I know you want to get down with this program tonight. Ray Brown has been in the trenches since 1974, all over the state, all over the country, all over the world. And that's about it. I couldn't do him justice with the couple seconds that I have, and he's already short on time. So Ray, my question to you regarding this topic, is there anything new here, or is this just a current manifestation of that which has existed since the founding of this country? I turn it to you.
I want to tell you that this is a wonderful opportunity, and I want to congratulate the people who do activate diversity. It's a wonderful program. It's a great idea, and I'm honored to be allowed to participate in it. That said, my good friend, and I put that in quotes, Cedric Ashley, has put me in a position of expounding on an extraordinarily complex and nuanced subject, and he's given me 20 minutes in which to do it. So let me jump into it because it is a vital subject. It affects our past, our present, and our future. It's impossible to look at this without seeing that in one hand, the title of this program invites us to look at the common law. And starting at about the time of Runnymede and the signing of Magna Carta, there also became a statutory and decisional tradition of looking at citizen involvement in law enforcement, because the idea of police is a very modern idea in Europe and elsewhere. And so starting in about the same time as Magna Carta, there were statutes and case law that talked about making more regular the use by constables, sheriffs, to use ordinary citizens to enforce the king's writ or the writ of a feudal lord. And it made a certain amount of sense in medieval England, and it was carried over to the colonies. And I suppose we could have a learned discourse about the evolution of the common law. The problem is that race gets in the way of a systemic and clear through line. Because you see, slavery was a lawless system. Slavery is now regarded as jus cogens, the term that international lawyers use for that which violates all peremptory norms and can never be delegated away. And you say, well, that's applying modern terminology and modern concepts. But I'm sure you're all aware that Jefferson, in his early drafts of the Declaration of Independence, condemned slavery as a vile criminal enterprise. He twisted it a little bit because he also blamed it all on the British Crown. They deserve some of the responsibility, but not all. And also said that it was equally wrong for George III to promise freedom to slaves, manumission in exchange for fighting against the colonial rebels. But nonetheless, it's always been regarded as a criminal enterprise. And it had some particular qualities, this criminal enterprise. It is based on race, the African origin of those enslaved. It denied them the very basics of protections that we expect to come from the rule of law. Bodies were not inviolate. Indeed, bodies were owned. It meant that sexual assaults could be authorized or carried out by masters, whippings, executions, all outside the framework of law. And so when people try to connect the early slave codes to the ultimate evolution of police, it is an understandable effort and it makes some sense. But remember, this is to treat people who were completely outside the framework of law. Their entire lives were existed at the behest of their white owners or those delegated by them to treat them. It's interesting, of course, that the leading race organization in the country trying to deal with racist effects is named Black Lives Matters. That might tell you what kind of issues we continue to wrestle with. But let's go forward, because slavery is critical to an understanding of how our system of enforcement involving civilians expands. Because remember, the Dred Scott decision was about the Fugitive Slave Act of 1850 and whether or not the enforcement activities, which included seconding citizens, having them participate in posses to chase fugitive slaves in free states, was one of the sparks that sets off the Civil War. But it also reinforces this notion in Tawny's infamous words that the Negro has no rights that the white man is bound to respect. Keep in mind, Tawny, although I'm sure he embraced that notion, wasn't speaking for himself, was talking about the founders. So the entire First Republic, up through the wartime amendments, the French have the grace and dignity to actually name their republics. We try to smooth over that difference. But the First Republic is full of processes that involve the use of force outside any framework that we would think of as a lawful framework against people of African descent. And that means tracing the nuances of the common law becomes difficult. Chiesa mentioned the Ahmaud Arbery case. He was just convicted this week of hate crimes, federal hate crimes, but his conviction of murder under the Georgia statute was in a trial in which he sought to use Georgia's citizens arrest statute, the three defendants did, to justify their conduct. What's interesting about that is that Georgia's original citizens arrest statute came about in 1861 as young men were being marshaled off into the Confederate Army. And it was a statute that presumed that a Black person could be arrested on the presumption, the statutory presumption that they were in violation of a law restricting them to their master's property and to behavior endorsed by their master, and was ultimately modified in some ways, which caused the judge in that case. But it still remains a part of our history to understand that the citizen's arrest concept was really imported into the common law and force to assist in the process of controlling the behavior of slavery. So there's very little that can be understood about our jurisprudence or the history of violence without understanding that. Now, what's interesting is not only is the Aubrey case redolent of the past, but this week a judge dismissed motions by Mr. Trump to dismiss a case in which he was charged by members of Congress with violating the Anti-Klan Act in instigating the events of January 6th. So again, the question of citizen activity becomes vital and can only be understood through the prism of the slave system and the denigration of Blacks. The other thing to keep in mind is that the draft riots of 1863 and 1864 were initiated because of the Draft Act, of course, but by whites who did not want to serve in the Grand Army of the Republic after the Emancipation Proclamation. They didn't want to risk fighting for the abolition of slavery. And this was in northern cities, in New York and Boston and Philadelphia, where hundreds of Blacks were lynched. And so we move forward into Reconstruction and the time of the wartime amendments when there's a hope that things will change. But it turns out that now you have the rise of the Klan and the beginning of efforts of the Redeemers to roll back the clock. The Klan Act of 1871 is part of that. The Hayes-Tilden Compromise of 1872, which withdrew the final 15,000 federal troops who were trying to keep enforcement. It isn't just laws that are at issue. There are early records of the Freedmen's Bureau show white men shooting Black men for failing to tip their hats. So you have both the enforcement of custom and the enforcement of hierarchy, as well as a law, which is the subject of sanctioned mob action. We then have a period of incredible lynching. It's interesting that Chisa gave you some names of some prominent victims of lynching. And during that time, in most Southern towns, everybody knew who the lynchers were. But the phrase that became to symbolize the process of lynch justice was killed at the hands of parties unknown, because grand juries and inquests would repeatedly fail to apprehend groups that often included law enforcement officials, but also citizens known to everyone. I think it's important to note the hierarchical effect of this, because we tend to think of citizens' arrest and the use of force by citizens as in service at least of the law, because even vigilantism is in theory an attempt to enforce the law without color of office. But in fact, it's often to maintain hierarchy. We all know about the psychosexual activity of lynching, but in fact, much of the lynching activity beyond that was not psychosexual was designed for economic oppression and to maintain power. For example, in 1892, the famous lynchings of Black men in Memphis, Tennessee, that made Ida Wells Barnett famous were over a Black grocery store that was competing favorably with a white grocery store. So you have activity that is designed to oppress and to terrorize Black folks into conforming their conduct to the nascent or revived power of the Redeemers. One other event that ought to be mentioned because it's so important, the Elaine riots of 1919. I focused on that in my life because my own grandfather was driven out of the South by a lynch mob that was after him because of his economic activity, but that's a story for another day. The Elaine riots involved tenant farmers who got together to form a co-op to sell their produce at a better price. They were attacked by a mob of whites. One of the whites was killed. There was a series of retaliations back and forth, and hundreds of Blacks were slain. There was an arrest of 40 Blacks. They were tried in two groups of 20. 5 of the defendants whose cases went to the United States Supreme Court had trials that lasted 45 minutes. You can read Moore v. Dempsey for Justice Holmes' famous opinion saying that the great writ does apply and reversing those convictions. But there's also now the specter of mob violence even infecting trials. It wasn't purely race. There's a case involving a man named a Jewish fellow who had been convicted in the Arkansas courts of sexual assault on a little girl, who went to the Supreme Court earlier, had his case denied, and was lynched by a mob afterwards. But you have the effect of Moore v. Dempsey. You have the case of Powell versus Alabama. Our Sixth Amendment jurisprudence stems from Powell versus Alabama, in which the Supreme Court dealt with the case, which also inspired To Kill a Mockingbird, in which the Scottsboro boys had trials that were criminally lacking in the kind of jurisprudence that characterizes our system, and also, again, where trials were affected by mobs. It brings us forward to the current era. And in some ways, it's interesting that Black Lives Matter comes out of vigilante justice directed at Trayvon Martin, who was a young man with skills, who had committed no offense. And interestingly enough, the trial only took place because of massive public pressure, because the initial decision of the prosecuting authorities in Florida was not to bring a trial, just as with Ahmaud Arbery. But for the video, there would have been no trial of any kind of him until there was public pressure and pressure from civil rights groups. And so there is a continued history in the United States in which mobs and those acting outside the law or those acting within the law to maintain racial hierarchy and terror have been used to use color of office in order to enforce terror. It's interesting that there is now a debate that's finally gotten started over from the Ahmaud Arbery case about eliminating the concept of citizen's arrest. And there is a model Citizens Arrest Act, and there's all kinds of intellectual debate about the parameters of that. But at the end of the day, the danger in our culture is that there is, on top of the veneer, because some of you will remember, if you're old enough, the frontier thesis, Frederick Jackson Turner, which was that American democracy was shaped in this sort of Marlboro Man way. This is the turn of the last century, by a kind of rugged individualism that made America different, and explains away a certain amount of intra-racial violence among whites. But the key factors in mob violence over the last 2.5 centuries has been that which has been characterized by an attempt to keep Blacks in place. And now that we've begun to deal with the questions of implicit bias, the question is, where do those biases come from? And do they come out of a tradition that involves the suppression of Black people and treating Blacks as inhumane in a way that is sanctioned by law and or custom? There's one final fact I thought I might bring to your attention that has always fascinated me. The Nat Turner Rebellion takes place in 1831 in August in Virginia. It's, by the standards of slave rebellions, pretty bloody. 50 whites are killed, some of them women and children, many of them people you would regard as non-combatants. In response, over 200 Blacks are killed, and Nat Turner is drawn and quartered. Immediately on the heels of that, there is the issuance in state legislatures in the Confederacy, except for Delaware, Maryland, and Tennessee, statutes prohibiting literacy. I was thinking this morning of Frederick Douglass's experience that he was taught to read by the wife of his master, who, when he discovered it, the master that is, prohibited her from doing it further, saying it's hard to manage these people. And that makes a connection between violence and this critical race theory concept that I'm glad you're going to take up, because it's not as though there's a serious debate in America about critical race theory, a concept advanced by some Black legal intellectuals, but rather an attempt to demean the very idea that Blacks can have notions that ought to be taken place in the marketplace of ideas about democracy and how we should be governed. I will say that these things have a profound effect, and it's hard to separate them from a tradition of lynching. I would say, if you're interested in my bias, in addition to my grandfather's experience, Emmett Till was lynched the day after my 9th birthday. And I recall, because his mother insisted that he have an open casket, hearing my parents debate whether to let me see next week's Jet magazine, which had the picture of Emmett Till with his face so brutally disfigured shown in the picture. And they debated it, didn't come to a conclusion, and left the magazine out. And I remember seeing that. And the reality, because Emmett Till was viewed by most as a response to Brown versus Board of Education. It was perhaps more powerful than the Southern Manifesto in saying, we will continue to maintain the racial hierarchy of the past. So I think it's important that we keep in mind that going back to slavery times, up through Reconstruction, which, by the way, was horribly distorted in the movies, whether it's Gone, D.W. Griffith's activity, or Birth of a Nation, or Gone with the Wind, continued efforts to keep Black folks in a dehumanized posture. Even January 6th can be thought of in 2020 as an attempt to take away any concept that we can exercise the franchise. So it isn't surprising that Justice Sotomayor in United States versus Reef, which is a case about a white guy who's the subject of a Terry stop, in her dissent talks about the talk. And what's the talk? It's the talk that Black parents have had with their children since slavery about how to deal with white men in authority. And she quotes Du Bois and Ta-Nehisi Coates. Interesting references. I don't know how often they've been cited in Supreme Court's opinions, but the continued issue of how Black bodies are treated, how Black people are treated, and whether equality under the law is a reality. If, for example, that horrible extrajudicial killing in Minnesota had not been the subject of videotape by those 12 citizens standing on the road and videotaping that, would there have been a trial? If we had not had a new progressive Black attorney general, would there have been a trial? Did a lot of factors have to line up to give the American people and the justice system an opportunity to look clearly at what happened? And so the notion that we are now in an era in which people say, and legislatures are actually saying, you cannot teach anything that might cause discomfort to some white folks, means that there is an effort to move us away from looking closely at these things. There's a legitimate debate about a citizen's arrest. You can have either side of that. There are, I suppose, circumstances where the constabulary needs the assistance of ordinary folks. But given the history of that process, given the terrible history of violence against African Americans, it's important to keep in mind that if we want to have a system which is open to all and accepted as just and fair by all, we have to keep in mind the horrible antecedents of the system born at a time when my ancestors were treated as though they were not human beings at all. So Cedric, do I have more time or am I done?
You're not done. You have more time on the back end. And okay. I knew that you could do what you are doing in this time period. You gave a great rendition of history in less than 20 minutes, but we're going to defer Ray's questions until Robbie speaks just because of scheduling purposes. So Ray will come back and give us more. But right now I want to introduce Robbie Kaplan, Roberta Kaplan. She came out of Big Law, created her own firm. So she's really still Big Law in a small package. And then she went down, before I got involved in this particular program, I knew about the Charlottesville. She's got all kinds of awards: Litigation of the Year, Most Innovative Litigator, Lawyer of the Year, all kinds of awards. But before I was putting together this program, I thought the person who, I'll say it, kicked some ass in Virginia was somebody local from Virginia. And I discovered this person was a New York lawyer. So she handled the Charlottesville, I call the Charlottesville litigation. It was the case of Sines versus Kessler. She took and used the 1871 KKK Act, and I'm sure there may have been some other causes of action, and brought forth litigation arising out of the 2017 Charlottesville demonstrations where various persons committed crimes upon innocent protesters back in Charlottesville and everything that was going on in Charlottesville in the Virginia area in 2017. And I think it was November or so that she got a wonderful verdict on behalf of the plaintiffs. And I throw it to Robbie with one question. Could you take us behind the scenes and tell us about your decision to take on the case, what challenges you face, and whether this type of litigation will be something that will be ongoing with your firm, and also just whatever strategy insights you want to give us about the power of using the KKK Act of 1871 to bring about justice. Thank you, Robbie.
Sure. Thanks for having me here. It's an honor to be here. And I think what I'm going to talk about Charlottesville and what you just heard from Ray, we all know to be true, which is history in this country and history on these issues never really ends. And to some extent, to paraphrase Faulkner, keeps happening again and again. And that's what we saw in Charlottesville. So let me tell the story of the case and point out, I think, some key things that are worth taking forward. The story of the case is I literally, Cedric had it right. I was a partner at Paul Weiss in New York for many years. I decided to form my own firm after the election of Donald Trump as president. We opened the firm on July 1, 2017. We were in our offices. The first week, I think, was the week of August 7th, 2017. I had all of, this is great that this is the small firm section of the ABA, because I think I had all of 4 employees when this case started. But that first week in our offices, as I recall, first full week was the week after Charlottesville. Charlottesville happened on August 11 and 12, 2017. And just to remind you all, the night of August 11, 2017, there was a torchlit secret rally that in March that was held on the campus of UVA. Hundreds of white supremacists wearing khaki pants and white polo shirts carrying lit torches, marched around campus, marched over the lawn, which is probably the most important and famous part of the campus and where students actually live, and then over the rotunda to the Thomas Jefferson statue, circled that statue, and there were some student protesters, including two of our plaintiffs, a young African-American man, Devin Willis, who was going into his sophomore year at UVA, and a young Latina, Natalie Romero, who were linked there. You can see the pictures of these kids literally being surrounded by violent, screaming, torch-bearing Nazis. That continued over the weekend, as everyone knows, to the morning. And after the violence of August 11th, Richard Spencer famously declared victory, said it was a great prelude to the next day. The morning of August 11th, there were repeated skirmishes around the Robert E. Lee statue in what was then known as Robert E. Lee Park, now known as Emancipation Park. That statue, as we all know, has since been taken down. And the events sadly and tragically culminated with James Fields, a white supremacist who had traveled from Ohio and had marched that day with Vanguard America, wearing their khaki pants, white polo uniform, and holding their shield, drove his car into a crowd of protesters who actually thought everything was over because the police had asked people to disperse, killing Heather Heyer, injuring many others, including Marcus Martin, who I'm sure people will recognize if they saw the photo. There's that famous Pulitzer Prize winning photo of a Black man being really thrown over the car. That's Marcus, our client. He pushed away his then girlfriend, Marissa, and saved her life before it happened. And that car also struck Natalie Romero, who had the bad luck to not only be there on Friday night, but to actually be struck by the car on August 12th as well. So back to the time frame, I just started this firm. We're in our new offices. Foolishly, on the next Monday, I decided we would, during lunch, watch the coverage of what was happening. And I thought I would order in pizza. It wasn't really a pizza eating type of thing. But as we watched the coverage, and that was the day that Donald Trump said that there were very fine people on both sides, it immediately occurred to me that we had a big problem here. The Civil Rights Division of the Department of Justice, which is the department formed after the Civil War in order to do exactly these kinds of cases, I believed, I think rightly, was not going to do anything about it. The Attorney General at that time was Jeff Sessions. As we all know, he does not have a particularly good record on civil rights. And I was very concerned that someone had to do something about it. And I didn't know who. And so I thought to myself, kind of in the crazy way I tend to think, well, I guess I will. The very next thing I did is I reached out to the Supreme Court writer, Dahlia Lithwick, who's famous, who writes on Slate, not but for her reviews on the law or the Supreme Court, but because at that time she lives in Charlottesville. And I said, look, I have this idea, Dahlia, what do you think? And she said, I think it's a great idea. Why don't you come down and I'll hook you up with some folks. So within about 72 hours of that call, we were on a plane to Charlottesville. We met with a whole bunch of the plaintiffs. We told them how hard it was going to be. We told them there wasn't going to be a lot of money at the end of the tunnel, even if we won, because these are not all, most of them are not wealthy people. We told them that if they brought this case, they would not be able to bring cases against the police for negligence or against UVA on a negligence theory because it would complicate this case. And every single one of these brave plaintiffs, including Marcus and Natalie and the Reverend Seth Wispaway, all signed up. So at that point, we had plaintiffs. We got a very lucky break on the facts. Someone, to this day, I do not know who it was, but someone hacked into the Discord servers that the organizers of Charlottesville used for many, many months to organize what they did. It was meticulously planned. They had a Charlottesville 2.0 server with sub-servers organized for leadership, transportation, uniforms, how to make it look like self-defense, etc. And someone had hacked into that and exposed not all of it, but a lot of it on the web. So we were able to read those messages, and from reading those messages, we determined who to sue, who we thought were the leaders of the conspiracy, and how to build the facts. The last thing that we needed, of course, was the law. And in a lot of ways, that was the hardest. we had needed a law that applied to private conduct. And as I'm sure all of you know, most of the civil rights statutes intended to implement the 13th, 14th, and 15th Amendments apply to governmental conduct. They don't apply to private conduct. But the KKK Act of 1871 does. And among other things, it's been really winnowed down over the years, but among other things, it does still prohibit conspiracies to commit racially motivated violence. So we had our legal hook. In terms of the history of the KKK Act, it's having a huge renaissance today. It's what's being used for January 6th and is being used for other similar incidents. But its history in the United States legal system is not great. It was used when it was passed in the 1870s. It was used somewhat successfully in the 1920s when there were terrible racial riots. And it was used successfully the last time, sadly, for a couple of Freedom Rider cases during the Civil Rights era. But the vast majority of KKK Act cases until recently were losers. They were cases that were filed by prisoners or pro se plaintiffs, and they almost always got dismissed or denied. So we had our case. We filed it in October 2017. The complaint reads like a huge nonfiction book. It's, I think, 200 pages long. And we filed the case in federal court in Charlottesville, Virginia. The next 4 years was a long marathon of seeking to get discovery from these plaintiffs. From these defendants. And it was a saga. We had a degree, as you won't be surprised, of non-compliance and contempt for the law that I've never seen before. 7 of the defendants defaulted completely. There were 12 motions for discovery violations and sanctions that were filed. We won 9 of them in full and 3 of them in part. The judge put Elliot Klein, one of the organizers of the rally, in jail for failure to comply with discovery. But eventually, over a long, hard period, we managed to get either from the defendants themselves, scraping data off the phones that they didn't throw in the toilet, but the phones that still existed, and from companies like Discord and Facebook and Twitter, a huge amount of data. At the end, by the time we went to trial, I think we had 575,000 posts on Discord. Trial was postponed not only because of the discovery delay and discovery misconduct, but also because of COVID. We were supposed to try it just before the election, the last presidential election. It got postponed until just after. The summer before trial, and this is ironic given what we've been talking about, the judge one day, sua sponte, said that he was thinking about moving the case to Lynchburg, Virginia. And what do we think about that? You can imagine my reaction. I rarely get that in your face with the judge, but I told the judge that he had absolutely no right to do that under the law, and that obviously we were very, very worried about the jury pool in Lynchburg, Virginia, and we had good reason to be. But ultimately, he denied the motion to change the venue, and the case went forward in Charlottesville. The trial itself was something, to say the least. We were under strict COVID conditions. They closed the entire courthouse in Charlottesville for any other case, any other proceeding. So it was only our case. The only people permitted into the courtroom were the defendants, including 2 pro se defendants, Richard Spencer and Chris Cantwell, the defendants' lawyers, the jury who were sitting, there were 12 jurors, and they sat where the public gallery would sit, like 2 people to a bench, and then the plaintiffs. There were no windows. We went for 4 weeks, 9 to 5, 5 days a week. And to be honest with you all, I have to say, I think that we probably won the case on jury selection. We started with a veneer of 169 jurors. Anyone who said they knew about Charlottesville or were there during Charlottesville or were upset about Charlottesville were excused for cause. The Black population in the jury pool counties, and Charlottesville draws from a lot of rural counties, was 14%. We got 5 Black people on our jury of 12, which was a miracle. At times I joked, I thought that God was intervening in our case. But I honestly think the real reason we got that great of a jury pool, is because very early in the case, one of the first Black jurors who had no basis for excusing him whatsoever, they issued a peremptory strike and we made a Batson challenge. And the judge, interestingly, withheld decision. I don't think he legally was permitted to do that, but he withheld decision until the end of jury selection. And what that ended up doing is disciplining the defendants so they didn't strike any more Black jurors through the rest of selection. So that's how we ended up with the jury. We had 3 non-vaccinated jurors, the rest were vaccinated. One of the non-vaccinated jurors, who I think was probably my most difficult juror, was excused the first day of deliberations because his kid's school had a COVID quarantine, and the judge said, since you're not vaccinated, I'm gonna excuse you today. As I said before, the trial lasted for 4 weeks. It was a bit of a circus, to say the least. The Judge Moon, who was appointed by Clinton and has been on the bench for many years, I think was very concerned about the appellate record. And so he gave the defendants a hell of a lot of leeway in terms of misbehavior and in terms of what they did. To give you an example, one of the young kids who was around that statute on Friday night, Devin Willis, young Black, today an older, teenage, I guess he's in his 20s now, Black man, testified on direct for 1 hour and 15 minutes. They crossed him for 6.5 hours. And they asked him questions that were frankly absurd, like, don't you believe that Thomas Jefferson is a white supremacist? Every question intended to inflame the jury, to inflame racial tensions, to make the jury think that this wasn't really about these kids being horribly injured as the result of a violent racist mob. And that happened over and over and over again. Finally, toward the end of the trial, the judge said to one of the defendants, you guys have spent all this time justifying your beliefs at the trial. And I honestly would say that was probably 40% of the testimony, but none of that's really relevant, because under the KKK Act, all the plaintiffs have to show is that it was racially motivated. Whether it's racially motivated or not, you can't rebut that by saying you're right to be racially motivated. But it was too late, and the trial lasted far, far longer, in my opinion, than it needed to. The trial was about crazy stuff. So a lot of attempts to justify racism, a lot of defenses of what they call the white ethno-state, which is what these guys want, either in part or all of the United States. A lot of talk of replacement theory, which I'm sure many of you know is the idea that it goes back to old anti-Semitic myths, going back hundreds of years, that this small group of conniving, wealthy, intelligent Jews are manipulating other racial groups like Blacks and immigrants and others to serve their ends. The book Mein Kampf came up at trial 5 times a day, as if you were talking about the phone book. And part of what the defendants were doing, part of their strategy in doing this, was to desensitize the jury. They wanted the jury to think that talking about these kinds of openly racist ideas was just ordinary discourse. And I'll have to tell you guys, to some extent they succeeded, because by the end of the trial, we were talking about concepts like this, or using phrases like Mein Kampf or white ethno-state as if it was everyday conversation. On the other hand, obviously, they didn't succeed, because after 3.5 days of deliberation, the jury came back with a $26 million verdict. We are now in post-trial motions. They are going to seek to knock down the punitives under Virginia law and under the Supreme Court precedents about there being too big of a gap between compensatory and punitives. We are going to seek a multi-million-dollar attorney's fees award to level the playing field on that. And I think if there's one thing that came across most in the, well, 2 things that came across in most in the case. One, that while I had my doubts, and while it was at times incredibly difficult, and while if the jury had gone the other way, I don't honestly know how I'd be feeling right now. In the end, the system worked. It wasn't ideal. It took too long. The plaintiffs were tortured. The defendants were allowed to get away with all kinds of bullshit that they shouldn't be able to do. But in the end, this jury of 11 people in what was essentially rural Virginia, more than half of whom were Trump voters, gave a verdict for the plaintiffs in our case. The second lesson, I think, that was just overwhelming to me, I think I never understood the concept of intersectionality before I was in this trial. Because the one thing that is absolutely true is that these guys, these white supremacists, which is a growing movement, and which, of course, these same guys led directly to January 6th, they hate all of us. They hate gay people. I mean, they hate all bunch of my identities. They hate gay people. They're not crazy about women. They hate Black people. They despise Jewish people, and they hate immigrants, Muslims, etc. And if we don't all work together to fight it, then we are not going to be able to fight it as effectively as we should. And it was just stunning in this courtroom, the way the defendants would slip from just violently anti-Semitic statements to violently racist statements to violently anti-immigrant statements. To them, it's all the same thing. And while these particular defendants, Richard Spencer has said that the alt-right as a result of our trial is now dead. While these defendants, I don't think can be successful and we're going to have much of a showing going forward, it has just continued in other groups and with other people. And the third thing I should have mentioned, the ultimate lesson in certain ways, is in the past, when the KKK Act was passed, when people wanted to meet together to have this kind of violent conspiracy, they had to do so wearing robes and hoods, right? That's how they got anonymization, and they met in the woods of Mississippi or Alabama to plot whatever lynchings, sadly, we already heard about that they were going to plot. Today, they don't need any of that. All they need is a hashtag and Wi-Fi. There are numerous websites out there who not only welcome these people, but advertise for them. And as soon as one of them, like Discord, starts to shut down this kind of discourse, it's like whack-a-mole. There's 2, 3, 4 others that show up to do it. And why it's even more dangerous today is now these conspiracies are not just in Alabama, not just local in Mississippi, they're nationwide and worldwide. People in Charlottesville came from all over the country to do what they did. And they believed that this was gonna be the battle, they called it the Battle of Charlottesville, to create, as a first step to creating the white ethno-state. I believe that they never will, but I believe that we have been extremely underestimating the threat of the growth of white supremacy, neo-Nazism, and these beliefs in this country in a way, in an organized way, thanks to social media and the internet, that is more dangerous than ever before. Thank you so much for having me. Happy to answer any questions, but really happy to be here.
So Robbie, you hear me, Robbie?
Yes.
Good. Okay, so thank you. Jamie, if you're still on, if you can, as you can see my different view, we've got tech issues here at the New Jersey Law Center. Jamie, if there are any questions in the chat box, if you can field those questions, that would be great. Either Jamie or Kelly, who's on. Any questions, please put in the chat box to Robbie.
I got you, Cedric, whoever.
Thank you. Yeah, Robbie, I zoomed out for a second, but powerful presentation, powerful work, and congratulations to you. So here's the question I will ask. Well, the question is being put in or whatever. What's next? I mean, do you see this as part of an ongoing program or firm, or maybe pro bono? It's just part of your firm, non-revenue. Well, maybe the judgment will generate revenue, but is it just you got to do it, so you're going to do it?
So look, honestly, for these kinds of widespread conspiracies like January 6th or Charlottesville, and sadly, I'm sure there will be others, the Justice Department is the best position, honestly, especially the criminal authorities with subpoena power, to, at least in the first instance, be the prosecuting force. In Charlottesville, that just didn't happen. There were some individual prosecutions. James Fields is in prison for life. Chris Cantwell is still in jail in New Hampshire. for threatening another white supremacist that he would rape his wife. But for the most part, they were only individual prosecutions and nothing looking at the conspiracy happened. And certainly there was no enforcement like that at all under the Trump administration. Under the Biden administration, it's obviously much better, but the problem there is they're just overwhelmed. My friend Pam Carlin is the second in command at Civil Rights, and she just tells me they just have so much to do at any one time that they just don't have the full scope of doing it. So for those reasons, particularly, God forbid, if our country goes backwards and we re-elect some like Donald Trump or someone like him, I think private enforcement is incredibly important. And I think reviving statutes that sadly and ironically were passed in the 1870s to deal with the problem then, and the fact that they're still needed today is incredibly important. We also need more statutes. The KKK Act has really been eroded by the Supreme Court over the years. It's not that powerful. It could be a lot more powerful, and Congress and states can do that. I should say, in all honesty, the jury hung on the KKK Act counts in our case. They rendered their verdict on the Tuesday before Thanksgiving. The judge refused to give them an Allen charge, and we didn't force it. But they did rule on the Virginia civil rights statute that was a state conspiracy statute that basically did the same thing. So even in the absence of federal legislation, making sure states pass laws like the Virginia statute that we used is incredibly important. And I certainly, to be clear, we did this pro bono. The attorney's fees we're going to give back to not-for-profits. I hope we collect money for our plaintiffs. And I intend to stay in this fight as long as I have to.
Jamie, I got your message. My audio may be coming in and out. Are there any questions? Looks like there's a question from Raymond Kinsey. Jamie, if you could read that.
All right. Any idea why the VA statutory claim was successful?
I think it was, I will never know. It was an anonymous jury. We insisted on that. We were not allowed to interview them. None of them voluntarily reached out to us, probably because they were afraid. But from the body language and everything else, it's my very strong sense that it was 10-1. There was one unvaccinated woman from a rural county who I think was the holdout juror. And you could see it because when they came in during those 2.5 days, the body language between her and everyone else was pretty obvious. So honestly, I think it was a compromise verdict. I think people wanted to get home for Thanksgiving and they tried to work on her and they just couldn't get her there. So they took the Virginia conspiracy charge instead. That would be my best guess.
Well, I wanted to congratulate Roberta and the wonderful work she and her team did. It's amazing. I watched from afar and I applauded the day they got the verdict. If you're confused that I'm here and I have Cedric's name underneath me, it's because I have the best of all worlds. I get to be me, but everybody will blame Cedric for whatever I do. But here in New Jersey, we're embroiled in a very deep controversy about jury selection. So you mentioned at the outset of your comments that you won the case in jury selection. And I wanted to know a little more about your approach to jury selection and why you believe that was key, because I think it's something that it's an issue. Race and jury selection is a big question around the country, and your insights, I think, would help everybody.
Yeah, so first of all, we did tons of work. So there was a 20-page questionnaire that this judge allowed that asked, literally 20 pages of question from issues concerning who you admire the most, who you admire the least, COVID vaccination status, which was really, frankly, in a lot of ways, kind of a signal for rationality or not. And a bunch of questions. I remember there were a series of questions that said, what do you think that discrimination against Black people is a problem? Still a problem, yes or no? Discrimination against Latinos, yes or no? Jewish people, yes or no? White people, yes or no? And I don't have the numbers at my fingertips, but I'm not exaggerating. About 40% of the jurors said no problem with discrimination today for Black people, Jewish people, Latinos, but huge problem for discrimination with white people. So the jury questionnaires as written gave us a lot of insights. And then on top of that, we had people doing internet searches overnight so that we knew who was coming in for the day. And I really think here it was a combination of research. It was that early Batson challenge, which scared the defendants, and they really didn't exercise any more racial peremptories. I would have loved He ultimately denied the Batson challenge. I would have loved that juror, but the other 5 we got were great. And honestly, I have to tell you, I don't know how to explain this to you guys, but I am not the kind of person who ever in my life wins on random things. Like, and don't take me to Vegas. Like, I'm just money pours out of me if I ever try to gamble or do anything based on chance. During this jury selection, and I can't tell you why, but every single random thing went our way. So we'd be facing, we'd have no peremptories left for the day. We'd be facing 5 or 6 really bad, jurors who looked really bad based on their questionnaires for us. And every single one of them would have a for cause challenge. So I can't tell you how it happened. All I can tell you is we did a lot of work and we got very lucky. And I think that those 5 Black jurors honestly made all the difference.
Was the judge receptive to the challenges for cause that your team made?
No.
Okay.
In a word, no. So
Okay.
they won almost all their challenges for cause.
Mhm.
But our people who were on our side, he would excuse. On their side, he would rehabilitate. I mean, they would say things like, I think there's no history of discrimination against Black people, Latinos, Jewish people. Yes, there's a problem with white people. He'd say, could you reach a fair verdict? And they'd say yes. And he'd say, okay, you're on. This was the South. I mean, it was the South for sure.
One might say, Roberta, this was America.
Yeah, that's fair. It was America.
Cedric, I'm sorry, go ahead.
I'm answering this question. So what does this case tell us about the lawyers who defended the case?
So that was its own thing. I mean, it was pretty insane. The worst of them is a Jewish guy by the name of Josh Smith, who at the first day, and he's the one, he said his strategy was desensitization. But the very first conference we had before the jury, he gets up and he gives this speech saying that as a Jew, I'm sick and tired of Jews who all they want to do is talk about the Holocaust. He's like, Judge, Jews, they just can't stop talking about the Holocaust, the Holocaust, the Holocaust. So I, listening to this, had to do everything I could in my power to keep myself calm, which I barely did, but I managed to do. And then I stood up in white hot anger and I said, Judge, we don't need to use the word the Holocaust. We can just use the defendant's own words. They constantly are talking about gassing the kikes, ovening the kikes, and burning the kikes. So that means the Holocaust, the judge, and we're happy to use their own words. But that gives you a sense of what these guys were like. There were 1 or 2 of them that were reasonable people who you could reach deals with, and we could negotiate with them in between court, in the evening. But most of them were very difficult. And the 2 pro se defendants really made it impossible. Richard Spencer, whose closing argument was about that he was basically Jesus and the Jews were putting him on the cross again, the Jewish lawyers. And Chris Canwell, who's already a convicted felon, and who I thought during his closing directly pointed at and threatened the Black jurors. And I went to sidebar and said something to the judge, and he didn't do anything about it. So in a word, it was crazy. It was complete crazy from 9 to 5, 5 days a week for 4 weeks.
Juan up.
Yes, I'm here.
It is.
So let's continue this conversation. And more questions, Jamie, feeding the questions. But Juan Thomas, we heard from former, not most recent past, but 2017, 2018, National Black Association, National Bar Association president. He's top 100 Black lawyers. He's chair-elect coming in for the Suppression Social Justice Action, and most importantly, he's a Morehouse man. What more needs to be said? Earlier, Ray had talked about the economic aspects of violence and vigilantism in the country.
Did we lose him?
I think we lost him.
I think we did.
But Juan, I think you know what the question is.
Yeah.
Because I know you've talked very much about economic oppression in your own family history.
So I wanted to share with my colleagues here the economic impact that this violence and these issues of systemic racism and outright vigilantism and active oppression has on people of color. There's a young lady by the name of Emily Ball, who in 1955 had a cafe and grocery store in a town called Yazoo City, Mississippi. Yazoo City, Mississippi is a town about 40 miles north of Jackson, Mississippi. And she was born and raised in Yazoo City, had 4 children. And in 1955, the NAACP approached her and asked her to sign a petition in response to the Brown decision to integrate the public schools in Yazoo City. She, along with 52 other African Americans, signed this petition. As a result of her signing that petition, the White Citizens Council in Yazoo City got together and decided to stop selling her product that she sold in her grocery store and in her cafe. And they literally put her out of business. As a result of that, she had to move her and her youngest child to Ohio because she couldn't get a job in Yazoo City. And several other of those people could no longer get work throughout the county of Yazoo County and in the city of Yazoo City. It was not until 1969 that Yazoo City began to integrate their schools. They ignored the decree from the Supreme Court with all deliberate speed. It took them nearly almost 20 years, 15 years to integrate public schools. Emily Ball's granddaughter was in the class of 69 that integrated not the school, but certain classes. And what I'm here to kind of highlight is the violence that may not always be overtly done to kill you, but to destroy you, to keep you in your place, that was done to limit your ability to grow wealth and economic opportunities throughout the South. Unfortunately, this is the story of many African-American families throughout the South, and as we heard earlier, just throughout America. Emily Ball's granddaughter is my mother. And that is what my mother remembers as a young girl going to Ohio to visit her grandmother, my great-grandmother. And I wanted to highlight that because that was directly impactful to my family. And so the ability to build generational wealth, to pass down the family business to my grandfather or to my mother or to me was eliminated because of systemic racism and the intentionality to make sure that African Americans were not going to speak up, speak out, and God forbid, want to have what the Supreme Court had ordered, which was the integration of public schools. There are so many scholars that have done work around this subject matter that I want to share with you that highlight these examples even more. There's a book titled The Age of Neo-Slavery. And it's written by by Douglas Blackman. And he talks about the re-enslavement of Black people after the Emancipation Proclamation of 1863. Over the next 100 years, it was these type of examples that were used to keep African Americans in their place. There's a book called The Color of Money, Black Banks and the Racial Wealth Gap, that reminds us that at the turn of the century, after the Emancipation Proclamation was signed, Black Americans had 1% of the wealth in this country. 150 years later, it had barely doubled. In fact, in 2017, white families had 13% more wealth than the median Black family. There's a documentary that has just come out that the ABA is promoting that I urge all of you to watch if you have not seen it. It's called The Color Tax. It is produced by Bruce Orenstein, who's an artist in residence at the Samuel Du Bois Cook Center on Social Equity at Duke University. He documents the predatory lending and the real estate practices to deny Blacks the right to buy houses, not in Mississippi, not in Alabama, not in Georgia, but in my hometown of Chicago. And so when you think about that wonderful work written by Isabel Wilkerson, The Warmth of Other Suns, that highlights the stories of African Americans who migrated from the South to the North. Those who came to the North still faced violence by economic oppression and economic injustice that is still tantamount today. Just 2 years ago, in 2020, a study was done by Citigroup that showed that Black workers have lost $113 billion of potential wages over the past 2 decades because they could not get a college degree. In the housing market, we've lost $218 billion in sales because Black applicants could not get a home loan. About $13 trillion have been lost in business revenue that never flowed into the Black community because Black entrepreneurs could not get access to bank loans and financing. Even though they may not lynch us anymore, and we could debate that because with issues around police brutality and other aspects of our common day life, we see that. But we see the economic oppression and the results of that oppression that still exists today. And so I think it's critically important that when we talk about the violence that is done to us historically and that still happens today, that we don't lose sight of those silent killers, the laws that are written, the policies that are underscored. There's a wonderful book called The Color of Law, written by Richard Rosenstein, that I urge you to also read, that talks about how public policy and laws were put in place that kept African Americans and other people of color oppressed and strangled their ability to have what we all want in life, which is a fair opportunity and a shot, and an honest shot at the American dream. And so I will pause there, but I want to just highlight the need to understand this history, not only from the overt violence, but those silent killers that were also done through public policy, systemic racism, and the law. Thank you.
All right, the first one is considering, this goes back, I think, to Robbie's case, considering the limitation of the Justice Department, is it possible that they might appoint special prosecutors, to take these types of cases?
You know, I'm not an expert on this story, but I think they have the ability to do that. I know state officials, I know here in New York, for example, state officials can, and I think many states have that ability to appoint special prosecutors. And it's honestly a shame that that didn't happen in Charlottesville. To be honest, I think the local prosecutors are now looking at a possible case based on ours, a criminal case based on the night of August 11th. They're still within the statute. And I hope that happens, but it obviously should have happened, 3 or 4 years ago. I just want to follow up on something Juan said. I'm pretty sure, in fact, now I'm almost positive that his mom went to the same school in Yazoo City that Carlton Reeves went to.
He's a family friend, yes.
He is one of my all-time heroes. There's no judge I've been more privileged to ever be before. And he told me that story about all deliberate speed in his class. So I'm honored to be here, even be here with you, given that connection.
I love Judge Reeves. He's a great guy. And my uncle was his biology teacher in high school.
Wow.
Yeah.
I hope he gets on a higher court very, very soon, would be my prayer.
Yes, absolutely.
All right, here's another one. What, if anything, can be done about abusive and bigoted trial techniques?
Look, I could just talk about in our case. I mean, we really tried. We did everything we could. And I have to say, by the end of the trial, 3.5 weeks in, the judge himself, who's an old white judge from the South, was fed up with it. And he started finally controlling it. But again, I think he was very worried that if he didn't give them all the rope that they wanted, that they would have real appellate issues. And the one good thing is they definitely have no appellate issues from this trial. But it's a balancing act. I should say Judge Moon is, I'm fair to say this, he's 86 years old. And I think, the trial was very hard for him. It was a long trial. It was exhausting. There were motions literally every day. And so maybe someone, if this case ever gets tried again, someone who looks at it fresh with maybe, a little bit more energy, I don't blame him for being tired, might have tried to attack those issues a little bit earlier than he did. I'm not attributing anything to his motives. He was trying to do the right balance.
So if I could, I mentioned earlier that we've had a great deal of controversy in New Jersey about race and jury selection. To its credit, our state Supreme Court in a case called State versus Andujar recognized that prosecutors in a particular case were using implicit bias to knock a particular juror off when they arrested him because he said he had friends who'd been arrested and other markers that relate to young Black men. Subsequently, we've had a fairly vigorous engagement with the court about what the solutions are. And I'm not sure I praise them as much for their administrative response as for their jurisprudence. But I do think that one of the things that's come out of this discussion is in the Batson context to develop an objective test. It's one thing for me to say that John Jones is acting in a discriminatory way or with discriminatory intent when he exercises a challenge. It's another to import from Washington and from California an objective test which said, could a reasonable person believe that race is involved in that challenge, as well as listing, those statutes do, particular pretextual arguments that are used in various places. So there actually is some serious thinking about one aspect of abuse, which is the use of race improperly to deal with challenges. I should say, there's another book I think everybody should read. It's a tougher book by Isabel Wilkerson. Juan is an intellectual who inspires us to think about books, called Caste. Oh, and it encourages us to, it's a tough book, not because it's written in a bad way, but it encourages us to rethink how we think about the world. And let me give you an example. One of my quarrels with my own state Supreme Court administratively is, don't roll your eyes, Cedric, that they want to limit peremptory challenges. And I think it's an overreaction. And for those of us who represent Black defendants, young Black defendants, to not have the ability to challenge people who have biases against them, I think misses the ball. And we have in those disputes, even some people who I'm allied with on other issues of social policy are against us because I think they say, understandably, we want to broaden the pool of people of color who get in the jury box. And we all agree with that. But how about questions of caste? Because some of those people are quite respectable, hardworking folks. What about Jamal? What about Tyreek? Do they get a fair trial? And so our willingness to look more deeply at questions that are uncomfortable and forbidden for all of us, Black, white, and otherwise, is a necessary condition for us to have success going forward. Just as, for example, Juan wants us to look at economic oppression. You say, well, why is he in on a conversation about violence? Because the two go hand in glove. They are inseparable, and the same people are at the bottom of the heap. And so our need to be more imaginative in our responses is an essential. And the advantage we have is none of us work with our back, although I wonder if Roberta wants another trial like that soon. But at least we're working with our minds, which are the tools that hopefully don't deteriorate like a backhand.
I mean, one of the things that we did, and to this day I'm heartsick about it, was preparing the plaintiffs, particularly the minority plaintiffs, for dealing with the baiting that we knew the defendants were going to do. And they just over and over and over tried to bait them. Isn't it, don't you think Thomas Jefferson was a white supremacist? Don't you think they should tear down the statues? All these things to try to bait the most kind of racist instincts of the jury. And it took hours of preparation to get them, it would have taken anyone to get to a place where they could sit there for 6 hours with dignity and just answer the same offensive questions over and over and over again. And Devin Willis in particular, I don't know how he did it. I mean, I would have lost my temper after 10 minutes, and he held out the entire 6 hours. It was really amazing. The only other thing I'd say about peremptories is not only do you have all the racial biases today, but with all this QAnon, fake news stuff, I mean, you get really crazy jurors. There are jurors today who literally are not tethered to reality and who aren't really subject to peer pressure. And so in my mind, you definitely want peremptory challenges to deal with that.
Can I just add one quick thing? with respect to, the violence and the economic impact, if you really drill down on what is the motive behind these violent acts, they tend to fall into kind of three buckets historically. It's when African Americans were trying to achieve voting rights. It's when there's been an assault or a alleged assault against a white woman, or it was to tear down economic opportunities where African Americans were trying to advance themselves either through a business or to achieve some level of status. So if you look at the Tulsa riots, what happened there? They burned down their businesses. They destroyed their community. There are several examples of that throughout American history. And so often the motive behind these violent acts was because African Americans were trying to achieve some economic status that was seen as out of place or out of sort by those who were perpetuating this oppression.
Well, one piece of rhetoric that ties together all the things we've discussed is this concept of the great replacement theory, that there is, especially among whites who have been made to feel that they are losing the game to people of color, is the notion that they're going to be replaced as viable cultural and economic entities. And it ties together violence, voting rights, discrimination, and to some extent, it is a challenge to leadership at every level, locally and nationally, to take that on. And part of it is, of course, moving away from people believing it's a zero-sum game. But you're also talking, as Roberta said, I hope I can call you Roberta, people who believe that there are lizards controlling the economy. Yeah. So it's a complicated task, but it seems to me there's actually a theoretical foundation for those who are acting against the concepts of justice that we're talking about.
So Jamie, time-wise, I think we're about to close out and Kelly will be coming on, but I think we've got about 3 minutes. So using that, jumping off from where Ray just left off with the whole notion of replacement theory, looking for the next 20 years, where prediction is America will be, America will look like the rest of the world. They say it's a minority, majority country. But what holds us as lawyers, litigators, social engineers, for the next 25 years? What is our charge? And what are we facing?
I think I understood telepathically what that question was. What I wanted to say is, I think some of this is we're tied together nationally and we need to support each other, but it's local. In New Jersey, for example, we have an incredible racial disparity in our prison system. It's not Alabama, it's not Georgia, it's New Jersey, which, by the way, during the Great Migration was called the Georgia of the North. But certainly that requires some strategic thinking about justice, about legislation, about litigation, as opposed to I have family who live in Georgia where the issue is going to be in the next 2 years, what to do about voting rights. So I think to some extent we need to support each other, but we need to be facile in understanding that, especially as the Supreme Court drifts far to the right out of view, that we need to focus on strategies that take on local projects, and where we understand what Charles Hamilton Houston said, that a lawyer who's not a social engineer is a parasite.
That's right. No, I would say candidly, as particularly speaking to lawyers, this is going to shock some of you. Consider running for office at every level. We need authentic, courageous, progressive minds at every level of public life.
Juan, you got my support as soon as you throw your hat in the ring. I got $1 here that goes into
$1, that's going to help. But we need talented people to run for office. When I'm looking at what's happening in this cycle with some of the folks who are running on these strange conspiracy theories, we have to step up, because that's where public policy is made. That's who decides. School boards decides curriculum, right? State legislatures decide voting rights in those states. Mayors hire the police chief. And so for this audience, those of you who've been blessed to get a law degree and probably have multiple other degrees, consider stepping up and running for office, get engaged, because we need to change and continue to impact public policy. And while I love the work that Roberta's doing, oftentimes that's on the back end after the law's already been made. We need those who can change the law on the front end, and that's public policy makers. It's a both and.
Here's for Juan's campaign fund right here.
I'm moving to New Jersey.
Welcome. We need you. We bring Roberta with you. Stop in New York on the way.
Right.
I was gonna say, there's no way I'd run for office in New York. No way.
In the next 25 years, kind of what's the strategy going forward?
Oh, God, I'm not smart enough to give you that answer. Look, I think right now we have a real problem in this country with conspiratorial minded. I mean, we've always had it, but now they have new methods to use and they are very organized. And we have to understand the very real risk that these organized white supremacists pose to our country. We saw it on January 6th. We saw it in Charlottesville. We saw it in attacks on Black Lives Matter protests, the same kind of arguments, the driving into protesters, the blaming it all on Antifa. It's the same theme every time. And I agree with Juan that it can't be done just in the courts. Courts are the last resort. We've got to organize politically in this country and bring back at least enough people to a sense of reality and dignity and at least some of the values that we all hold so dear. Because there's parts of this country that really feel very foreign, at least to me right now.
So one area that I think we need to focus on, and this will dovetail with Juan's concept of running for office, because many people start running for local school boards. 37 states have instituted some kind of anti-intellectual, part of American history, of course, limits on what can be taught in schools. And in most instances, they're saying, don't teach something that's never been taught, critical race theory. But you have tremendous movement away from any honest engagement. I think Stephen, who was the first person to speak, talked about discomfort. If the principle is you can never make anybody discomfort, especially if they're white, that means we can't talk about anything that's happened in American history. No society is perfect, especially if it has noble aspirations. But if you're not willing to talk about the flaws and the failures and how we can be better. So to the extent that education is a place where not only in New Jersey, there is desegregation litigation going on now, but in addition to that, the notion of getting engaged in fights over curriculum, getting engaged in school board races. And once we have Juan as governor and Roberta as attorney general, it's going to be smooth sailing.
30 seconds, real quick, Jamie. I saw a post today that made me think about what Ray just mentioned about, things being taught in school that are uncomfortable. There's a picture of a young Black girl in Arkansas being escorted into school by the armed guard. That's uncomfortable. Okay? That's uncomfortable. Imagine having to have your children escorted into school by the military. That's the history of this country. That should be taught. And I'm sure that young girl, those young students were uncomfortable. I'll stop there.
This is Kelly Adams here, and I want to personally thank everyone for attending this phenomenal series, Activate Diversity series, the long and tragic history of racism, vigilantism, and mob violence in America. Thank you to our wonderful panelists. Thank you to Cedric, our moderator, and thank you to everyone who attended. Conversations like this must continue because change must occur. And I want to thank you for the final comments that you made, because it leads us to our next program that we would like to invite you to. March 31st, we're going to continue with these comfortable, uncomfortable conversations. Activate Diversity, the privilege of criticizing critical race theory. It's scheduled for March 31st at 5 p.m. It's virtual, and you can register now, and we will have it in the chat where you can register for that event right now. We'd also like to invite you to submit a video of how you've been inspired to activate diversity. And the video, we just ask you a few seconds. I will lead an Activate Diversity by, And then how do you plan to do that? That link is also being added to the chat. Lastly, we have our Activate Diversity Pro Bono Pledge. And we'd like to know, how could you get involved with more pro bono activity? How can you help your community? How can you help the communities that are lacking diversity? So please join us while we try to activate diversity. It's more than just talking about it. We need to do something. Thank you for joining us today.